Good morning. May it please the Court. Beth Whitman appearing on behalf of the defendant, Catherine Salmi. I would like to reserve 2 minutes for rebuttal, and I would like you to speak up. Certainly. I can certainly do that. Will it help if I raise it maybe a little bit? But I would waive the free fire zone as well. The issue here is whether a mental health... Pardon? At your own risk. Absolutely. The issue here is whether a mental health professional has a duty to third parties to who might foreseeably be harmed by the techniques that are used by that mental health professional that allegedly implants false memories of sexual abuse. For a multitude of reasons, it's defendant's position that the Court of Appeals erred in finding this duty and imposing that duty here.
Counsel, good morning. I'm just in rare form today. Why is it that you shouldn't be able, but your client shouldn't have to face a jury?
Because before the Court of Appeals issued its decision, there was no duty that went to the parents or to a third party. The duty always went to the patient himself or herself. And this is
But would you not acknowledge that the damage that was done here was done tremendously upon the parents? Your client basically accused them of a sexual molestation.
That's correct.
Isn't that an incredible damage that is done upon to them?
It certainly could be. And again...
Could be. How is it could be? You wouldn't stipulate that that is not a horrible thing, that your child is going out telling the entire community and city that they were molested?
If it's not true. That's what I'm saying. I'm saying it could be if it's not true. You also, I think, have to look at the opposite, which is that it could be true. And if that's the case, then we have a significant policy decision here that we have to make. And we can't just look at the allegations in the complaint to make that policy decision.
But law enforcement did an investigation and found that it wasn't. Is it, in fact, your argument that this could be true? Is that your argument today?
Absolutely. The investigation files are included. They're part of the record. I'm sure you've read them. They are terrible. They include terrible allegations that this young woman made against her parents.
But no action was taken?
That's correct. But that doesn't mean that it didn't happen. I mean, these were allegations based upon the investigation reports that are in the record that occurred when the child was 7 and 8 years old. There would not have necessarily been physical evidence of that abuse at the time that they were.
This is a C-8 motion, isn't it?
That is correct.
We have to assume that this is false.
But for purposes of determining whether or not a plaintiff has met the elements of a claim, then I agree with you on a C-8 motion, you have to look at it. But when we're talking about policy, when we're talking about weighing the policy, then I don't think that we should be bound by the allegations in the complaint. Because I think what we need to do is we need to look at everything.
Does that mean that this is the wrong stage of the case for us to consider this issue?
I don't think so. Because I don't think even if, in the majority of cases that have, or other states that have looked at this, they have even accepted as true the fact that recovered memory therapy has been used, that these are false allegations, and they still have held that as a matter of law, this duty does not flow to third parties.
So let me ask this. Oh, I'm sorry. So why is a therapist different than an ordinary medical doctor?
Sure. I think it arises merely because of the fact that mental health treatment is not an exact science. And that's found within the case law as well from other jurisdictions. They put it simply, I know this sounds kind of silly, but you can't take an x-ray and make a determination whether or not somebody is telling the truth. You can't tell whether or not they've actually been sexually abused.
But doesn't that mean it'll just be harder to prove proximate cause and cause in fact and breach?
Well,
it doesn't necessarily mean for purposes of thinking about a duty. I'm depressed, I go to a therapist. The therapist says, I know what I need to do. I need to treat you with leeches that are infected with Zika virus because once you get Zika virus, you'll realize that your other problems are really not that bad. So I get the leech treatment, I get Zika virus, I go home, I give it to my husband, and no duty? Therapist is just so different from a doctor that there's no duty?
Correct.
Or is it really that it's just harder to prove cause and breach?
Well, the duty would still go to the patient. The duty would go to the patient.
My husband has no claim.
Your husband, I agree with you, that your husband would have no cause of action because he was not in a relationship.
But why? Because surely...
She treated me with leeches.
Surely if Justice
Zika
McCormick
leeches.
went to a medical doctor and said, I have a problem, at whatever her medical claim is, and the doctor says, I know, leeches. That's how we're going to cure this. And so does the same thing, puts the leeches on her body, and then she gets Zika virus, and then she transmits that to her husband. He would have a claim, right?
No, I don't think that he
Why
would.
not?
There's no relationship that exists between
But we have cases about like meningitis and stuff. So if a doctor misdiagnoses somebody, a medical doctor misdiagnoses somebody and says, oh, you don't have meningitis, but in fact you have meningitis, and then you go out and you communicate it to
Your kid.
to other
foreseeable-
people.
Your kid dies.
Okay,
and your kid dies, I think the doctor is liable.
but
So
I think the
I'm trying to figure out
difference,
why this is different.
the difference would then be, I think, is that under those circumstances, the patient and the person who got Zika or got meningitis would be in the same shoes as the patient. There's no conflict between the treatment of the patient and the treatment of the person that gets that disease. Here, however, we can't say the same thing. You have a treatment of a alleged victim of sexual abuse, and now the Court of Appeals has held that there is now a duty that is owed to the alleged abuser. So it's different. It totally is a different situation because it puts the mental health professional in a situation where they are divided loyalties between.
Well, but counsel, shouldn't it actually do that in a lot of ways? And again, you're doing a great job. I just, we've got a very hot panel today, so it's a lot of drama. But the point is that shouldn't it though? I mean, this is a case of first impression. This is a case, that has a lot of policy implications. I mean, don't you feel that a therapist, before a situation where basically you're using suppressed memory, you don't feel that there is a substantial impact upon the people who are being accused of horrific acts?
Well, just because there may be a significant impact on the people that are being accused, I don't think that that's a valid enough reason to find that there's a duty that exists. I mean, we also have to look at the
But
fact.
they should have a blanket immunity then? I mean, but don't you worry that if you're going to look at this from this kind of a policy perspective, wouldn't you then worry that parents would say, oh my God, I'm not going to take my child to see a therapist because if I choose the wrong therapist, my life could be ruined because everyone's going to think I'm a child molester. So don't you think that if you have blanket immunity to the therapist, it could ultimately go in the opposite direction?
That's certainly, I suppose that's one policy concern, but you have to balance that with the policy concern of being able, a mental health professional, being able to treat their patient in the best way that they think how.
But treat them responsibly, though.
That is correct, but.
And you feel that the science that was used here was a responsible method of treatment?
Well, again, it's an allegation as to what was used. The defendant counselor denied that she uses this type of therapy. She filed an affidavit of meritorious defense.
So shouldn't we find out what really happened? Like, shouldn't we have the opportunity to do some discovery to see what's taken place?
And that's also what Justice McCormick said. Under the circumstances here where we have specific privileges that apply, how can they do that? The Court of Appeals completely sidestepped that issue. There is without the waiver.
Isn't that a C-10 question? Whether they can prove the claim?
Well, under these circumstances, how can they do that? How could they do that? We know that they attempted to take her deposition and that there was an order that precluded her deposition from being taken because her therapist indicated at that time that it would be detrimental to her mental health.
That goes to whether those proofs can be established, not whether the cause of action should be recognized.
But I think
this is a C8.
I agree. I
You
understand.
take all the allegations and all the reasonable inferences therefrom and make a determination whether it states a claim.
That's correct.
Prior to the Court of Appeals case, there was no duty.
Correct.
Now we have the imposition of a duty.
Correct.
That's what we're here for.
Correct. But my point is that we have policy in this state that protects victims of sexual abuse. We have a broad policy against protecting victims of sexual abuse. We also have a broad policy of protecting the communications between mental health professionals and their clients. Based upon that, that goes to the underlying policy of whether or not this cause of action should in fact be.
Correct. Isn't the oddity of this case that although the patient appears to be perfectly happy with the therapy she got, it's the third party, her parents, who are upset?
That's correct. There is no alleged injury by the patient. The patient is claiming that she absolutely believes that this abuse occurred.
That means that they're never going to be able to show cause and fact, proximate cause, breach. I mean, but you didn't convert this to a C-10 motion. Maybe you should have, but.
No, I don't think that, I think that allowing even this cause of action to go forward can result in harm to the patient.
More
Because
specifically imposing the duty.
that's
right?
correct.
Is it an oversimplification of your position to say that if you impose this duty, and there's dual duties, one to the patient and one to third party, that ultimately what's going to happen is the therapist, in trying to decide what therapy to use, is going to take any therapy that can produce repressed memories out of the therapist's medical bag, and that could be detrimental to the patient.
Correct.
And because of this conflict, the duty should go strictly to the patient and not the third party.
That's exactly correct.
Is that an oversimplification of your position?
I don't think so at all. I think that's exactly what I'm saying. And I think that, when you have these concerns, that just allowing the suit to be filed is potentially
Here's the
problematic.
point. Here's the point. Since unless there's a duty here, ordinarily, if there was malpractice, therapeutic malpractice, the patient would be able to sue, and there might be some derivative claims that the patient could add. But what we have here are the derivative claims now being given primacy when the principal, the patient, is not contending that there was malpractice.
Correct. And I think that's a complete anomaly in the law. I don't think that this has been, this type of action has been allowed to proceed in any other situation. So I think.
Well, that's not true. The circuits have been split on this. I don't think that's a true statement.
No, I'm saying in this state. I
this
agree.
state, yes. In other states, that's not the
There are
case.
a minority of states that have allowed this cause of action to proceed, and in fact has carved out a common law exception to the privilege statute so as to allow the parents to pursue this cause of action. They then get the mental health records of their alleged victim. They're taking the deposition of the alleged victim in this case in an adversarial context where the patient is not a party to the claim.
But my question is, it wouldn't always have to be the case that the derivative claim would be the only claim, right? So it could be the case that the patient here said, oh my gosh, they used this quack therapy on me, and I now realize that that all those memories were false, and that did damage to me, and it did damage to the parents. So it's not all, the question here, we're on C8, and so the question is, should this be a claim at all? And it's not always going to be the case that there will be divided loyalty, right?
It's not always the case, maybe, that the patient is not bringing the lawsuit.
Right, so the patient might be bringing the lawsuit and the parents, they were both harmed.
In which case,
Which
there's
is
no
like the
need
leeches.
for an additional duty to the derivative claimant.
That's correct. And I also would go back to Justice Zara's comment, which it still then undermines the underlying mental health treatment that can be given to the patients, because I think that some of the case law defines or describes it as being defensive therapy that the mental health professional is then utilizing in treating patients when there is a dual duty owed not just to the patient, but to potential third parties that could be harmed by the mental health treatment.
Ms. Whitman, I
Yes.
understand in attempting to determine whether or not there's a common law duty of the sort that's at issue in this case, we, among other things, look to balance the social utility with the creation of the duty and the disutility in creating the duty. And I think we all have a rough sense of what interests would be furthered if we were to create a duty here and what interests would be retarded if we were to do that. But my question is it relevant to know in trying to weigh these duties, these utilities and disutilities, is it relevant to know something more about the reality of this therapeutic procedure? In other words, in particular, how frequently false memories tend to be implanted in this process? In other words, if false memories are implanted in 75% of all the therapies in which this is at issue, it seems to me the social balance is significantly different than if they're implanted in 10% of cases. What does this court need to know in order to reach an intelligent resolution of the common law question before us.
What I would suggest in response to that is that maybe this court is not in the best position to make those types of determinations. That maybe that would be something that would be then left to the legislature.
What about the fact that as articulated by the Court of Appeals, the duty is not in any way limited to the implantation? It is an imposition of a duty to third parties who might be harmed by the therapy.
Right, right. So
It isn't, I mean, I think that's the indeterminacy of the duty as articulated should be a factor in the balance or weighing of utilities and detriments.
Yeah, and I think it's extremely broad the way that the Court of Appeals indicated it, because it doesn't even have to be an improper technique. I mean, it can be in a completely proper technique of mental health care that's provided, and if it results in false memories, then it's still going to be something that a third party can then turn around and sue the mental health professional for.
But is it still not relevant for us to know just how frequently these false memories tend to be produced?
I don't think that should be necessarily a relevant issue, because, again, you're still going to be in a situation where you have that conflict between what the therapist can do for their patient and that they're constantly...
So on the one hand, this can be quasi-voodoo therapy in which 90% of the time false memories are produced, or at the other end of the spectrum, this can be an indispensable procedure for identifying previous sexual abuse that may have caused great harm to a minor patient. And I think it makes no difference to us whether the reality is A or B.
I agree with that, because I think it's the underlying issue is that it places a mental health professional in a
But shouldn't there
very
be
bad
some,
situation.
so there should be no level of accountability or even analysis of risk that this therapist should have to engage before they induce such types of therapy?
Well, there's always
Just blanket immunity?
There's always the accountability that's owed to the patient. Additionally, there's always licensing issues as well. I mean, anybody can make a report to the Bureau of Licensing and state that this...
Once you make an accusation about child molestation, in this situation, the accusation was made about the child and then another member of the family. And once you start making these kind of accusations, it's impossible to take them back. I mean, for all intents and purposes, those words are out there, and it's very difficult for a person to ever recover from that. What we're trying to do is understand the balance. What you're basically saying is that there should be complete and total immunity. That if a therapist wants to induce any technique, they can induce any such technique without having to do an assessment of the risk that it's going to have upon other individuals.
I'm not indicating immunity, because, like I said, there's always
immunity
the patient.
For the third party, who's
immunity
the one who's
for the
really
third
impacted.
party. Yes, because the duty of loyalty always goes to the patient, always, and it cannot, in the circumstances of mental health care, it cannot be divided.
But isn't this the only kind of situation where you literally have third parties who can be directly impacted and affected by the conduct of the therapist?
Under these circumstances that the Court of Appeals has initiated, this is, to my knowledge, this is the only type of situation where that can occur. For mental health treatment that's provided to a patient and a duty that's owed to a third party.
Don't we have both Michigan and federal statutes that specifically refer to the parents of a patient, the parents of a minor, as being encompassed within the term patient?
We do.
Is that relevant in determining whether or not we're ranging so far afield by treating parents as being within the universe of people whose harm can be foreseen in this circumstance? We're not talking about teachers. We're not talking about aunts and uncles. We're not talking about neighbors. We're not talking about the corner hardware dealer. We're talking about the parents, the very persons who give permission to engage in the therapy in the first place, which also leads me to a second question. Although I realize this is more a standard of care question than a duty question, the record doesn't seem to reveal here whether or not there was any informed consent that was provided by the parents. I don't know whether that's part of the standard of care here, but can I ask you just as a factual question, did the parents provide such consent?
I don't know the answer to that. I don't know. But with respect...
I take it you don't see that relevant either in this...
I don't. Because, again, for an informed consent, an informed consent claim, it still goes to a negligent injury by the patient. That's a claim where the parent is saying that you didn't give me sufficient information, and as a result, my child was injured. That's not what plaintiff's claim is here.
Nor is it what the Court of Appeals said. Michigan's common law recognizes a duty of care to third parties who might foreseeably be harmed by the mental health patient's use of techniques that cause his or her patient to have false memories of sexual abuse. The third parties here are not limited
That's
to parents, not even to relatives.
Correct. I think it could fall to clergy, to school, teachers, professors. I agree. I don't think it's limited. I think it's an extremely broad rule that they have
Our case could be
created.
limited any way the court thinks it ought to be reasonable to limit it. The fact that we have a statute out there is not designed to suggest that that's the only way we can conceivably limit our common law decision. It's just to suggest that it would not be without precedent for there to be some sense that a parent is situated in a way to have a legitimate interest in this context.
And I want to go back to your first question with respect to treating a parent as a patient. I'm assuming that you're referring to the Medical Records Access Act as well as HIPAA. Both Medical Records Access Act and HIPAA both describe that a mental health professional or covered entity or health professional does not have to treat the parent as the representative of the child if that health professional believes that abuse or neglect has
But
occurred.
Counsel, I appreciate that, but isn't that different? Isn't that different? Because in that situation, someone's coming in and saying, this happened, I was molested, this is what took place. Isn't that a little different from induced memory, where ultimately this is an induced situation over a number of sessions and through a lot of praise and support by the therapist as they continue to delve into this, and that this is something that is induced, that's not coming voluntary, like I came in and this is what happened. This is something that is induced
Allegedly,
through
again,
memory,
allegedly.
which could be flawed.
It also could be true.
And in this case, it was seen to be flawed.
But I don't, only the plaintiffs are alleging that it's flawed. The patient absolutely believes that this occurred.
But that takes us back to C8.
It does.
We don't really want to argue the
but-
facts of whether it's true or it's false. Let me take you back a few minutes to
Okay.
a statement you made.
Please.
This is purely a common law claim from the plaintiff. Agreed?
Agreed. Absolutely.
Yet you suggested that we defer to the legislature on this duty. And this court is really charged with defining the common law in this state. Can you help me understand what standards we should articulate in an opinion to utilize when we should defer exercising our duty to interpret the common law and punt to the legislature?
Well, I think, like in circumstances where this court has made a decision that we are not going to decide that there is a common law duty, it has been this weighing of the policies, and that the legislature is in the best position to weigh those policies, to hold hearings.
They're better than this court on a question of common law?
I think that, well, whether or not the common law should be expanded, I understand the Court of Appeals has done that, but whether or not that should be allowed, you know, this court has repeatedly held that the legislature is in the best position, that they can hold hearings,
Yeah,
they
but
can have.
Look, I've written on this subject, and I understand that there are occasions when the issues are so complex. Our world today has so many different actors and interests. Sometimes it's really hard to figure out whose interests are paramount and so on. Those are occasions where perhaps it's best to defer to the legislature. But this is not that circumstance. We have a well-developed body of common law that generally says a professional has no duty to a third party. We have, in the context of lawyering, there is no duty to a lawyer performing services for a client to act on the behalf of third parties unless they fall within the identified objects, third-party beneficiaries that the client intends
Right.
to serve. this is an exception from that whole line of doctrine. There is no general duty to third parties for professional services unless there's an express recognition of a third-party relationship that is to be served by the professional. How does that inform us of how we should respond to the Court of Appeals invocation of a broader duty?
Well, I would say two things. I agree with you. I think all of the policy considerations are out there, and I think they weigh in my client's favor. So I think this court absolutely can make a determination. My comment with respect to the legislature was made more in response to Justice Markman's comment that do we need to have more research with respect to the recovered memory therapy, that type of thing. If we need research, testimony, that type of thing, then that would be something that I would submit would be more appropriate for the legislature.
Well, why isn't that a very legitimate question, a court that is being asked either to approve or disapprove a common law addition to the duties of a professional? Why wouldn't we want to know what Pandora's box we might be opening if we don't know what the underlying issue, recovered memory or induced memory, actually entails and how broadly it's practiced?
And so I would submit then that if we don't know, then I don't think that this cause of action should go forward. If it could cause irreparable harm to allow these causes of action to go forward to the patient herself, which is what I'm advocating.
Well, we don't know, but I thought Justice Markman asked a reasonable question. Do we know that this is a and that doesn't happen often. If we don't know whether this is a favored, disfavored therapy, isn't that something we ought to understand?
I don't think, and again, I go back to what Justice Zara said, I still don't think under these circumstances here that it makes any bit of difference, because regardless of what was actually done in this particular case, an overall broad duty that was imposed by the Court of Appeals is entirely improper.
The question is, if we knew somehow, we don't, that it's complete quackery designed to implant false memories 100% of the time, and we happen to have a videotape because this family we're doing some like reality TV special where they had their whole life videotaped all the time. So we actually knew it didn't happen, 100% knew it didn't happen. And we knew the technique was 1,000% designed to produce false memories. You would still say that the general the general policy implication not to get in the middle of a relationship means we should say overall no therapist, no quack therapist ever has to buy any liability insurance?
Only to the patient.
Maybe they should buy liability insurance if that's what they've decided to they want to only perform this, what we now know is 100% quackery designed to hurt people. Why don't we want them to just buy some liability insurance?
Well, I think the duty runs to the patient, and then also you have the licensing issues that would stop somebody who is doing complete quackery.
So take care of it in the licensing.
But the patient is going to make a claim in that case.
Typically, you would think that they probably would.
If it's 100%, right? If it's 90%, is the therapist going to take this approach? If 90% of the time you're going to get whacked with a malpractice claim.
Right. And again, I don't think the expansion of the duty to the third parties is going to make it less likely that they would be negligent.
Can I ask a question about the background norm here? So the Chief Justice just said, look, the background norm is, in tort law, is no duty to third parties.
Correct.
But are we sure that's right when the risk is foreseeable? So let's say I'm driving a car, this actually happened, I got my tires changed and they didn't tighten the bolts on the wheels. And so I'm driving my car and then my wheel falls off. Now, thankfully, I wasn't injured. That's actually where my story ends. But let's say I wasn't injured, my kids weren't injured, but we rear-ended somebody in front of us and that person died. Is the guy who failed to, so I'm not injured, the duty ran to me, he tightened my bolt, he's not liable to the guy that I killed?
But again, it's like the
it's
Zika
foreseeable that if he doesn't tighten the bolts
sure,
on my wheel,
it's certainly
will fall
foreseeable.
off.
It's certainly foreseeable, but again,
So that's my question. What's the background norm?
The difference, though, under those circumstances is there's no conflict between the duty that is owed to you and the duty that is owed to the third party to prevent that accident from happening. Here, there is a conflict between the duty that's owed to the patient alleging sexual abuse and the alleged
Sometimes.
Well,
abuser.
there can be.
Yes,
Right.
yes,
There
absolutely.
can be, and so that's the difference. is
That's the
that in-
difference.
In my wheel fall-off case, there can never be a conflict, but in this case, there could be a conflict.
Yes, I think there's an inherent conflict between,
There's always a conflict when the parents really did it, and there's not a conflict when they didn't, right? I mean, this is, like, it's not that there's always a conflict. Sometimes there is and sometimes there's not.
there might not be, I agree. But I still think that the risk there outweighs any risk or any
Right.
injury to
And
the
I think your
parent.
time is up.
Okay, thank you very much.
May it please this honorable court, Zachary Kemp, on behalf of the appellees, I will reserve the 5-minute free from fire period.
I don't blame you.
Wisely.
Yeah, really. You should ask for like 20.
If only to express one point, and that is a point that I think that has been overlooked at every level that this case has proceeded through, both at the Circuit Court of Appeals and in the questioning I've seen today in this court, and that is paragraph 14 of the complaint, which alleged that these people were not just third parties, they're not just parents, they're patients. This court could easily do away with all of the nonsense and question regarding third-party liability in a simple reverse, remand, go back to the circuit court and treat this as a first-party case. Because then we lose the question of duty. It's obvious there's a duty. Patients, it's been conceded that patients always are the recipients of the duties of loyalty, the duties to be treated properly by a therapist. In footnote 2 of the Court of Appeals opinion, they just glossed over that fact. They said, well, because we're deciding that there's third-party liability, we're not even going to address this issue of whether or not they were patients, and we're just going to create this, not create, but expand this body of existing law. And that's what this is. This is not a new body of law. Courts, the general rule, yes, is that there is no third-party liability under standard principles of negligence. However, that has been chipped away over the years by the jurisprudence of this court and the courts of appeals in adding exceptions to the case, in which there should be third-party liability, and that is even in the realm of medical malpractice, where we start with Davis v. Lim. It is a Court of Appeals case, but again, and this was not pre-Tarasoff, but pre the codification of Tarasoff. That's 330-1946. But in that case, the court did extend liability, but only to victims who were readily identifiable. And I believe that's what the Court of Appeals did in this case. And even looking at their opinion, and I know this was discussed, but I feel in reading the opinion, specifically in Section D of the opinion where they talk about the limited duty, they do mention parents, specifically parents, as those people who are the foreseeable ones of this risk of harm. Now, questions have arose regarding, whether or not this should belong solely in the province of the patient. The problem here with limiting this type of cause of action only to the patient is that the therapists themselves, by virtue of this therapy, by virtue of implanting these false memories, by virtue of making this person believe this happened, is taking away the only person that can sue them. They are, in essence, limiting their own liability by eliminating the potential claimant. It's possible one day that a person could get over these false memories that were implanted in their mind, but it runs the same risk that what if a person goes on living the rest of their life believing their parents molested them? Again, so the question is then, well, how can this therapist be held responsible? And that's where we come in, by allowing this third-party standing by the parents. These people are foreseeable. They are the most likely person, or group of people, I should say, to be affected, and the limited duty as prescribed by the Court of Appeals doesn't open the floodgates of litigation here.
You know, counsel, I understand.
I'll waive the balance.
Thank you. I mean, as a matter of shorthand, false memories, bad, true memories, good. Okay?
Yes.
Is that a fair starting point?
The
Yes.
Frankenstein formulation.
I've read your briefs, I've looked at the record, and I really don't have much of a grasp as to what this procedure produces in terms of results. Does it produce more good or more bad? And if so, what is the relative proportion of the good and bad? I just don't have a sense of that. And it seems to me all quite indispensable to making an intelligent, balancing decision of the sort that we're required to make in determining whether to create common law duties. Will you provide me with some guidance to explain to me better why we ought to create such a duty here?
Certainly. Again, I don't know necessarily that we're creating a duty rather than expanding existing case law to cover a situation such as this. You know, this, and I mean, because this
The Court
is
of
covered
Appeals
under,
thought it was doing that.
because this is covered under the
Why do you
medical.
think you're here? Really? Why do you think you're here?
I'm here because they appealed. But
Well, but do you think that we wouldn't have granted if this wasn't a significant
I do
jurisprudentially
recognize and
significant
understand
issue?
the significance of this decision and its impact on the
Okay,
jurisprudence of the
answer
state.
Justice Martin's question.
I'm sorry.
Answer his question.
Well, I do feel that because this is under the Medical Malpractice Act, because it's under the Medical Malpractice Statute, we do have some things leading up prior to the case even being filed, such as the notice of intent and the affidavit of merit, in which these types of modalities and therapies are addressed by an expert who says, essentially, true memory is good, false memory is bad. And they establish, it does become a standard of care issue, which, you know, is normally a question of fact rather than a question of law, such as duty in this case.
Yeah,
Now,
but that's why we're here.
That's
As the
correct.
Court of Appeals, I thought you said something extraordinarily important at the outset. This is a C-8 motion. I kind of think of modifying the common law as a very great big deal. It's the one area of the law that empowers judges to make law. Everywhere else in the positive law, we follow the legislative's lead or the parties in a contract lead or the Constitution, the people's lead in reading their words. Here we get to make up what the law is. And that's a really big deal, I think. But what you said was, this is a C-8 motion in which you have alleged that the parents of this child were the patients of the defendant. And that was kind of an illuminating epiphany for me, because had the Court of Appeals merely applied the controlling standard for C-8, giving all the allegations, to treat all the allegations as true, including any inferences, they should have resolved it on that basis rather than creating this far more dynamically troubling potential change in the common law. What have you got to say to that?
I agree completely with that.
So
So do
your
I.
position is you would be satisfied if we said, well, there's an allegation here that the parents are patients of the therapist, and the common law duty plainly runs to a patient, and so therefore we vacate the rest of the Court of Appeals opinion that talks about this duty to third parties? You're good with that? And then the suit can go forward, but it goes forward on they're
On
the
the merits
patients,
of your-
the parents are the patients.
Your claim.
Yes.
Works
Simply.
for me, too. Anything else?
So then it's a fact question of whether they were or weren't parents?
Correct.
We're not patients?
Patients, not parents.
And if it turns out they're not patients, then of course your suit is over.
At that point, yes, and then I would feel at that point that this level of inquiry and at this, inquiry into whether or not the duty should expand to third parties, that would be the appropriate time for the appellate courts to deal with that question.
Okay.
But at this time, they're patients.
Did the trial court rule on that ground? I don't remember.
It was addressed in the motion for reconsideration. Again, it was a quick gloss over by the trial court, which just said...
They're not patients?
It didn't necessarily say that they weren't patients. It said that...
I don't see, if you've alleged that they were patients, how the court on a C-8 motion could say, I disbelieve that allegation.
I think everything got wrapped up into the argument regarding third-party standing with, the multitudes and multitudes of other...
And I just don't have the complaint in front of me right now. If there is an allegation that the parents were patients of the defendant, then as I understand the appropriate standard of review under a C-8, the court was required to treat that allegation as though it were true for the purpose of determining whether a claim was stated. And if the trial court failed to give that allegation the treatment of considering it a fact, that would be a legal error, would it not?
Yes.
Who paid for the treatments?
The parents.
Paragraph 3, plaintiffs are the father and mother of K, a former and/or current patient of defendant.
I'm sorry, that's K.
I'm sorry.
I believe you're looking for paragraph 14.
What paragraph was
I
it?
believe it was paragraph 14.
14, okay.
In which, and I can...
See, I'm a member of a public body, and I'm not responsible for that. Anything else?
No, certainly, I'm here to argue the case that third-party liability should be extended in this case, in this situation. I'm not here to just say they were patients, case closed, let's go
Well,
home.
let me go to 14. It isn't nearly as explicit. On
says
July
that-
14th, 2009, defendant invited plaintiffs to a session with K under the auspices that the meeting would be a joint counsel. So it's you're alleging that they were engaged in counseling with the defendant.
Correct.
Okay.
How do you deal with the mandatory reporting requirements?
I'm sorry?
How do you deal with mandatory reporting requirements?
Mandatory reporting requirements, and I didn't brief this here. However, I'm somewhat familiar with it. The mandatory reporting requirements require that the therapist report allegations that are true. There is some liability to the mandated reporters if they knowingly report a false allegation. This would be an example of the daycare worker that doesn't like their client anymore, and they make an allegation that the child had abusive things. There is liability and thus, it's no longer operates as the immunity shield around the mandated reporter in that situation. What the allegations are here is that, of course, we have alleged and we believe that the statements regarding the sexual abuse are not true, and in fact were implanted, came up with, created by the defendant. Ergo, the immunity granted under the mandatory reporter statute wouldn't apply in a situation such as this, especially under the auspices of the C-8 motion, where we specifically allege those are not true.
What's your answer to your opposing counsel's argument that the relationship between a therapist and patient is sort of different than the car mechanic and Justice Larson or other professionals and their clients / patients, because we have this greater interest in not creating a wedge between the therapist and patient, which we might if the therapist was always thinking about how not to make everybody else in the patient's family and circle angry?
Well, what the therapist should be concerned with, and this again goes to a standard of care issue, is using proper modalities that do not implant nor enforce false memories. I mean, it benefits no one to be told and convinced of something that did not occur. So the duty to the parents does not run any differently than the duty owed to the patient to use proper therapeutic means. So we're not creating another duty, we're essentially allowing a separate class of potential plaintiffs, and a very limited class at that. Those who are most directly impacted by this particular modality.
In what sense are the parents intended third-party beneficiaries that the therapist ought to keep in mind when treating the patient?
Well, I thought the Court of Appeals did a good job explaining this in their opinion. It's not just that they're a third-party beneficiary of the intended treatment, but rather that
it must. I mean, ordinarily, if you're giving legal advice, you're not liable to third parties for giving the legal advice, with one exception: when there are identified third-party beneficiaries, right?
correct.
Foreseeable victims. That's like
And-
black letter tort law, right? Foreseeable victims.
Correct. And I mean, there are a multitude of other examples in which professionals are held liable to third parties, such as the case of the architect. This is cited in my brief. And architect designs a building, it has a fatal flaw, their direct client is the owner, operator of the building. However, when the whole thing collapses, and it's because of the architect's fault, everybody in that building is a victim, due to the fact that they are foreseeable victims.
That's like the auto mechanic and Justice Larson.
And
There's
also-
never going to be a conflict between the duty owed to Justice Larson and the people she may hit when her tires fall off. Same with the architect and the building. The duty is the same. They're never going to be in conflict. What is the potential for a conflict between patient and foreseeable third-party victims do to make us think about duty differently here, if anything?
There isn't necessarily a conflict, and specifically in this instance, there is no conflict that I see.
there's not always a conflict. It's the potential for a conflict that might make us weigh the policy considerations differently. That's the question.
There's an absolute conflict here because the patient herself is not suing the defendant and in fact opposes the third-party beneficiaries of this Court of Appeals theory.
Well,
It's a patent conflict in this case.
And I would say that, again, this does touch on this particular type of treatment in this particular case, this very limited, and this is an issue of first impression in this state, so this is a very small type of matter in which we're dealing with here. The point is that the patient, the first party, the individual who, no doubt there's liability, they cannot, will not, and refuse to sue this therapist because of the acts of this therapist. This is a similar analogy would be the.
The way
Okay,
they're
so
gonna
wait,
defend
so-
this claim is by bringing Kay in. And, are you satisfied with the therapy you received? Do you believe this to be true? How certain are you of it? The whole defense is going to be by bringing this person in who's going to say it's not false at all.
And again, they could have asked those questions, and I think that touches more on a C-10 issue than the C-8 issue that's before the court, but there was a
It's that
deposition
conflict
scheduled.
that causes me great concern. Right? The therapist is put in a bind of trying to decide what therapy to use and whether I'll take something out of my list of things I can use because one particular therapy might result in exposure to third-party liability, even though many would believe that this is what is actually necessary for the patient.
Yeah, so let's go back to meningitis. Let's say
Is this
that
the
there's.
leech thing?
No.
No, I'm
This is an
going to try
actual
and
case
go
where
with meningitis, not leeches.
Okay.
But I could do leeches. Let's say that there are two treatments. Patient has meningitis, first party patient. I could treat with treatment A which has a 100% chance of curing the meningitis, but won't do anything to reduce its communicability. I could go with treatment B, which has a 50% chance of curing the meningitis, but a 100% chance of making the disease not communicable. Now, the doctors in the audience are laughing. There is no such thing. But let's say that there is. Is my duty to the patient to choose the 100% chance of curing your meningitis, but your kids are going to get it, or to the 50% chance of curing it with the patient, but your kids won't get it? If I'm the doctor, where does my duty lie? And isn't that case kind of like the problem that Justice Zara is worrying about?
Here's my response to that is that the hypothetical that you're posing does not sort of misses the nail head here.
Okay, why?
In your if you're in a situation like yours, how I would see it would be not that you have a situation with 100% cure, but there's the communicability issue. Rather, the physician in that case, to be analogous to this, would have the opportunity of a 100% cure and actually, through an act of that physician, spreading it. This is a misfeasance type action. This is active negligence.
This is only because you say it is. You are positing to us that there is never a modality which might create a recovery of memory that couldn't be a positive therapeutic technique.
But that's because we asked the question at the C8 stage. We asked an academic question.
Yeah, well, I'm just saying, this is all postulated on an assumption that the treatment modality results in 100% detriment, whereas it might be a perfectly legitimate technique that doesn't result in a high rate of false memories. We don't have any clue about the validity of the technique involved here. But you are in order for us to impose the duty, we have to make an assumption about whether this kind of technique, which is what the focus of the duty is wrong. And it always produces or tends to produce false memories. Do we know anything about that?
No, and I think that's where it gets to
well, then
the
why
fact
would we, if we don't know that this is a therapeutic technique that should be suppressed, why would we create a duty in this context?
Because we create a duty in every medical action that is done by any doctor, therapist, counselor. And this goes to the point.
But my point is, Justice Larson's, as far as we know, Justice Larson's hypothetical is this case. Sometimes this is a good therapy that produces great outcomes, and maybe sometimes it doesn't.
And to answer that, I say that that is a question of fact as to whether or not there should be liability. That goes more to liability, I would say, than to duty.
After we find a duty.
I'm trying to figure out, I mean, you want to create incentives with duties. And I'm worried about, we may be creating an incentive for therapists that is detrimental to their therapeutic mission with their patients. That's the concern I've got. And I don't know enough about the underlying therapy technique that your clients are positing happened here to know whether we should be extinguishing that or even touching on it.
I would say that because the impacts of this court, they're huge. They reach everyone in the state. They affect the jurisprudence. And I would say that
that's what makes me cautious. A
rule of law that could be established in this case would be to the duty would be to not do these things that implant these false memories. However, the saving grace there.
You have made a factual conclusion that this technique results in false memories. It may do that sometimes. It may do that all the time. It may do it rarely. And if you're creating incentives by creating duties, you ought to know what those incentives are. And I don't think we have a record to do that. That's why when I'm facing common law issues, I'm very cautious because I don't know what the real world impacts are, and you haven't been able to explain to me what the real world impacts are of an incentive duty bound incentive to extinguish this particular kind of therapy.
Well, I don't know that I'm suggesting that this particular type of therapy be completely extinguished.
How can it not be if we create this duty?
Because we also have, in the context of a medical malpractice action, the defense's side. The defense experts can come forth and review the record, review everything that was done, and they can say, you know what, in this particular instance, this was the only.
I'm positing here Justice Larson's hypothetical. We have two treatment modalities, one that favors
Well, we have law, and Justice Larson's hypothetical, our law says the doctor has a duty to tell her, and then if she chooses the course of action that infects her children, there's not going to be any causation, because she's going to break the causal chain. So I'm not, Justice Larson's kids are out of luck, sorry. It's not her fault.
You gotta tell
Can I ask a different, I still think like we haven't figured out the answer to what the potential conflict means at this like initial stage of imposing a duty. But let me ask you just one other question that I don't know what, it may be not relevant at all in figuring out duty, but if it is, I want to know. These cases are hard because the tort system likes quantifiable harms, and meningitis that infects your baby and your baby dies, that's like a quantifiable harm. And reputational harms, I'm not quibbling that they're not real, but they're harder to quantify. And that's going to be, except for my Leach's example, what we usually have, right? Reputational harms. Should that cause us any concern about drawing a new duty line for, mental health professionals? The fact that the damages are so wishy-washy and harder to quantify, and the tort system doesn't really like those, right?
Well, I would say that in regard to the damages, I mean, obviously we're going to, assuming the case would go forward, we'd be able to present.
I meant harm, really. I mean, I know I got distracted with the term damages, but just the harms are not exactly the type the tort system is comfortable with quantifying. Should that mean anything to us at this first order question stage?
In looking at the harms versus the harm of not doing anything, I guess, would be the balancing interest. And, the harms of not doing anything are, they're evident. I believe it was Justice Markman or Justice Bernstein who indicated that it's hard to ignore and it's hard to argue that the harm that these plaintiffs, these parents have faced it's unimaginable to be not only labeled as a sexual abuser, but of your own child. Now, if we go a step further, and this sort of goes into my argument regarding why we shouldn't allow just the patient themselves to be the only plaintiff, and that's you can imagine a situation where there's a cyclical pattern of abuse by therapists. We have to imagine the evil conniving therapist saying, I have a great idea here. I'm going to implant these false memories of abuse into this person so that they alienate their family. They think I'm the godsend, I'm the savior. I continue treating this person and I get to keep billing insurance. I get to keep making money off of this person using this condition that I created. Now that's a harm, that's an evil that should be addressed, and I think that by imposing this duty and by recognizing...
The problem is it's all a balancing test, isn't it? What worries me is there is an assumption here that the treatment modality itself is evil and therefore it should be extinguished. And the converse is maybe it isn't, and maybe what this duty does is make the therapist the insurer of the truth of what the patient tells him in the therapy. And I think that's a pretty untenable position. given what therapy is, given the variability of human behavior, thought, I don't know if the patient says, I think my parents sexually abused me, how the therapist can be made the insurer of the truth of that statement or the untruth of it.
And I agree that it is difficult, however.
Well, doesn't the difficulty balance away from imposing a duty? If a therapist has to decide, is this real abuse, or is this patient confabulating, creating stuff out of whole cloth? What is my duty at that point? My patient tells me my dad sexually abused me. What do I do? Do I take out a polygraph?
That is a different scenario. That is the scenario where
it is only because your starting point is the therapy technique that produces this statement is evil. If you don't make that starting assumption, then a lot of other things come into play, like what I'm suggesting.
And I can appreciate that scenario where the patient comes to the therapist and says,
no, as a part of the therapy, it comes out over time.
I think that, and I look to the Johnson case out of Wisconsin. And that case dealt less with recognizing a duty, but more with breaching the public policy concern of confidentiality. And the remedy that the Johnson court came up with sort of, I think, addresses that in these types of cases where we're dealing with recovered memory therapy or the implantation of memory, there are patterns, there are things that can be seen, and thus what that court imposed as a prerequisite in that case to gaining access to records is that the plaintiff comes forward with expert testimony through an evidentiary hearing, which establishes a likelihood or some standard, I believe a preponderance standard, that this type of negligent therapy occurred. And at that point, there is an in-camera review of the records, and it follows a long line, the Stanaway process.
Counsel,
Okay. Oh, I'm sorry. I just had one last question that might be interesting to Justice Markman, because I think it follows up on his earlier concern about limiting this liability to, the third-party liability to parents. The Court of Appeals said this is just about parents. Justice Markman seems interested in cabining this just to parents. Do you agree that that is the right standard and a plausible line for us to draw? Like, why parents and not uncles?
Siblings.
Siblings, uncles.
Well, I believe that parents were singled out just due to the inherent fundamental constitutional rights that parents have to be able to raise their children. It's been recognized.
Siblings are foreseeable.
Siblings are foreseeable, and I don't know.
And you think that it is any less crisis to a family to have a sibling accused of sexual abuse?
I don't know that I would draw the line there at just parents.
So you wouldn't defend that line. You think the line is any foreseeable third party, uncles, aunts, siblings, grandparents.
I believe that whether or not
Teachers.
not the victim, but I believe that whether or not the potential plaintiff is foreseeable agrees with the jurisprudence of allowing third-party liability in this state. And foreseeability is, I mean, this court announced it in In-Re certified question for the 14th District. Foreseeability is one of the biggest chunks or biggest inquiries that must be made in order to determine whether or not there was a duty.
Counsel, I very much agree with what the Chief Justice said a while ago about the importance of the common law to promoting or furthering incentives and disincentives. At the risk of repeating myself, however, I really feel that we're totally at sea here without knowing more about what the reality of the status quo is. That is, what is the present record of effectiveness of the recovered memory procedure. Without knowing more about the realities of the status quo, I don't know how we can make the very determinations that are necessary for common law development. In particular, I don't know what needs to be incentivized most of all. Do we need more to incentivize ceasing negligent implantation of false memories, or do we need to encourage recovered memories more? I don't know. And I also don't know what will in fact be incentivized most if we create a new common law duty here. Will it be more of the former, or will it be more of the latter? I just think we're at sea here, and I'm hard-pressed to understand that the burdens don't really fall upon you in creating a new duty to explain to us what will and will not be incentivized if we adopt your point of view, and what will not be, and what will be disincentivized at the same time. I just feel at sea in answering the very questions that are necessary here.
He's at sea because he has no further time. Thank you very much.
Can I just ask him to respond to that, please?
Sure.
Do you have any response to that?
Well, as I stated previously, there is no incentive to allowing people to walk around with memories of things that didn't happen. So I would say the incentive would be, number one, to prevent that, prevent what would otherwise not be, I mean, by any stretch of the imagination, allowing someone to walk around with false memories can't be good therapy. We would disincentivize then the other scenario.
Yeah, but are there detriments? We don't want bad things to happen, right? But do they always happen? And the other question that he asked was, what does creating a new duty to a non-patient do to the therapeutic relationship?
And to that, I'd say nothing more than what's already established under the current standard of care.
Nobody ever purposely creates false memories, do they? It's always an inadvertent result in the course of attempting to secure correct memories. Isn't that right?
It depends on how evil you think the therapist might be.
But the purposeful one, we would have an intentional tort theory, I presume, to recover. So we're only talking about the negligent imposing of false memories.
I don't think that any therapist would want that as an end result, no. I don't think that any therapist engaging in therapy, but I do think that they would limit their methodologies and modalities, the therapy that they use, to those tested and true things that will not result in that. Thank you.
Thank you very much. The case is submitted.